At the beginning of the course, we talked about the difference between procedural and substantive due process. We now return to take a more systematic look of the concept of procedural due process and how it relates to administrative agencies. For this part of the course, we're focusing on two specific parts of the Constitution. First, the Fifth Amendment, which says, "No person shall be deprived of life, liberty, or property without due process of law." So we want to make sure to take a look at that. No person shall be deprived of life, liberty, or property without due process of law. Of course, this is the due process clause, but we want to take special note that it applies to property as well as to life or liberty, and we'll see why that's important in just a little bit. Another important part of the Constitution when we're talking about due process is the 14th Amendment, which says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The reason the 14th Amendment is important is when the Bill of Rights was originally written, it did not apply to the states. It only applied to the federal government. So the issues of federalism that we've previously discussed are important even here. So the Fifth Amendment did not originally apply to the states, it only applied to the federal government. It was the addition of the 14th Amendment that applied the Bill of Rights to the states. Therefore, any time a state government is sued for violating any provision of the Bill of Rights, including the Due Process Clause, the litigants have to cite not only the original provision of the Constitution that was alleged to have been violated, but they also have to cite the 14th Amendment. So, for example, if you're suing a state government to say that they violated your First Amendment right to freedom of speech, you have to sue them under both the First and the 14th Amendments in order to win your case. So we're focusing on these two amendments in this lecture. As you already know, there are two types of due process: procedural due process and substantive due process. And as you already know, challenges based on substantive due process rarely succeed. Substantive due process challenges are lawsuits when litigants say the agency merely reached the wrong decision. It was just wrong. And as you know, in our American system of government, these kinds of challenges rarely succeed. And in fact, I want to introduce now a new legal test, but this is the easiest test the government can meet under the law. Anytime a litigant challenges a governmental action under substantive due process, simply saying that they reached the wrong decision, the agency then has to defend itself, but in defending itself, it merely has to meet what is known as the rational basis test. And again, this is a very, very easy test for the government to meet. Under the rational basis test, all the government has to do is demonstrate that its decision was irrational. Or conversely, it merely has to demonstrate that its decision was not irrational or that it was not arbitrary. And it's usually very easy for administrative agencies to demonstrate that they behaved in a rational manner. Court in 1998, in a otherwise non-significant case, County versus Sacramento v. Lewis, said, "Cases have repeatedly emphasized that only the most egregious official conduct can be said to be arbitrary in the constitutional sense." So only the most egregious, outrageous, arbitrary, abusive conduct can be overturned by the courts using substantive due process. Now we're going to return to this yet again later in the course, but for now we'll go ahead and we'll leave this aside. So let's focus on procedural due process. Of course, these are challenges made not on the substance of the decision, but on the process by which the agency used to come to its decision. Now, it's important to keep in mind that for our discussion today, when we talk about procedural due process, we're only talking about agency adjudication. Agencies do two major things. They engage in adjudication, and they also engage in rulemaking. The procedural due process principles that we're discussing in this video only apply to adjudication, but do not apply to rulemaking. And so at this point, it becomes very, very important to figure out what is the difference between those two things. Earlier in the semester, we talked about, in a loose sense, the difference between adjudication and legislation. Well, now we revisit those concepts because obviously agency adjudication is very similar to adjudication in a court. Agency rulemaking is very similar to litigation. And so the courts have been called upon to define more formally what is the difference between agency adjudication and agency rulemaking. So let's go ahead and take a look at what the difference between these two concepts is. And the two cases that I want to talk about both involve property tax, and they both involve property tax in the city of Denver, coincidentally, so these two cases are very, very easy to compare. The first case we're going to talk about is called Londoner v. Denver, which was decided by the Supreme Court in 1908. In this particular case, the city of Denver had engaged on a road improvements project. And the idea was that individuals who lived on or near these roads were going to benefit more than those who did not. And so property owners in Denver were assessed a property tax. And it was based on a complicated assessment formula and whatnot, but everybody was assessed their share of the costs related to road improvements. Some owners disputed their assessments. They said, that's not fair. I want to appeal the amount that you are saying that I have to pay for. The city of Denver did permit objections, but they only permitted objections in writing. Londoner and other litigants argued that they were entitled not only to a written hearing, but they were entitled to an oral hearing as well. And later on in the course, we'll talk about why that's so important, what the advantages of an oral hearing are, but nevertheless, Londoner argued that they were entitled to an oral hearing. The question in this case is whether or not this do they require an oral hearing? Is that required under the law, or is a written objection sufficient? The next case, and we're going to compare these two cases, but the other case that the court heard on this issue was in 1915, Bimetallic Investment Company v. State Board of Equalization. In this case, once again, there's a property tax increase in the city of Denver, but this time it was simply a 40% increase across the board. So you did not have individual assessments. Everybody's property taxes were increased by 40%. The Bimetallic Investment Company once again objected to this increase, and they demanded a right to be heard, and the Denver said no. So what's the difference between these two cases? The court ultimately said that one of them represents an issue of rulemaking, and the other represents an issue that calls for adjudication, and they should be treated differently. So I'm curious. The court decided in one instance that the property owners were entitled to an assessment, and they argued in the other instance that the property owners were not entitled to challenge their assessment. And I would ask you to think for a moment, which one do you think the court said that challenging the assessment was legitimate, and which one would you say that the court said challenging the assessment was not legitimate? The answer is that the court decided that a hearing was required in the first of those two cases, the Londoner case, but that a hearing was not required in the Bimetallic case, the second case. And why is that? Well, in doing so, the court distinguished between the concepts of rulemaking and adjudication. What's the difference between rulemaking and adjudication? When you think about adjudication is usually, two parties battling it out in court. Rulemaking is the legislature making general rules for society in general. Well, in fact, the court in these two cases said that yes, One of the things that distinguishes rulemaking and adjudication is the very nature of the decision itself. Does the decision affect individuals as individuals, or does the nature of the decision have an effect on everybody equally? So if it's a decision that tends to have variable effects on different parties, then it's more likely to be adjudication. But if the decision has a general effect or an almost identical effect on everybody, then this is more likely to be rulemaking. In addition, and this is related to the first criteria, the effect of the decision is important. And again, some parties are exceptionally affected when it comes to adjudication, meaning they carry a heavier burden. And when it's rulemaking, individuals and companies are equally affected, so the burdens are spread across the board. So these are a couple of the factors that the court uses to determine when adjudication is required, when rulemaking is required. And of course, the number of parties affected is going to be important. Usually, although it's not always the case, and we'll talk about this in a moment, usually adjudication affects a smaller number of parties than rulemaking does. So, let's focus on each of these three factors briefly. First, let's talk about the nature of the decision. I think this is very interesting. So, if there is a decision that affects one individual's situation especially, and it affects one individual's situation differently than somebody else's, then to decide that dispute requires something that the courts call adjudicative facts. Adjudicative facts. Adjudicative facts are facts that may be only known to the parties themselves. So let's say that somebody has been assessed a property tax increase, but their house has burned down, and the government doesn't know this. Well, they would probably want to be able to go to a hearing and to explain to the government, hey, I know you're assessing my property at this value, but my house has burned down. That is a fact that you don't know, but I do know. And it's very important. And so having some sort of trial, having some sort of adjudication is very important, so this very significant fact can be brought to bear on the decision. So, adjudication is called for in those situations where the decision requires facts that are only known to certain parties. So, for example, in the Londoner case, everybody was assessed differently, and as a result, they had different stories to tell about whether their assessment was fair or not. Legislation or decisions that have a general effect don't require adjudicative facts. They only require what are known as legislative facts. Legislative facts are facts that don't require any special knowledge by the parties. So if the city is raising taxes by 40% across the board, well, everybody's just going to raise that. There's no special dispensation for anybody. There's nothing you could bring to bear and say, well, I deserve not to have my taxes raised by 40%, but because I'm special. There's no special knowledge that any particular litigant can bring to bear, and as a result, there's really no need to have an adjudication. What about the effect of the decisions? You'll recall that a adjudication is more likely to be called for if the decision has an exceptional effect, as opposed to whether on certain parties, as opposed to whether it has a general effect. Now, this question is usually pretty easy to answer. Are some people more affected than others? But not always. So here's an interesting case. It was not decided by the U.S. Supreme Court. It was decided by the Second Circuit. Airline Pilots Association v. Quesada. In this particular case, there was a rule that had been issued by the federal government, by the FAA, that forced pilots to retire at age 60. So this is a rule that applies, it would seem to me, it applies to everybody across the board. It applies to everybody equally, right? But in this case, Quesada sued, saying that this did not apply to everybody equally. He said, you can't just have this blanket rule. You can't just fire everybody at age 60. What you have to do is you have to have an individual determination determining whether or not pilots are fit to fly. Now notice, this is the big difference between adjudication and legislation. The rule is legislation or rulemaking. This applies to everybody, 60 years old, whether you like it or not. It's what we call a hard line rule, and you're done. You turn 60, you're out. Quesada, of course, was demanding an adjudication. He was saying, no, I don't want a general rule to apply to me. Every single person should be able to determine or to prove for themselves that they are still capable of flying. In this case, the Second Amendment rejected their argument. Because, of course, what they decided was that this is a legislative rule, not adjudication. And as a result, it could only be challenged, or it couldn't be challenged because it was rulemaking, not adjudication. And remember, that's what we're talking about. You can usually challenge rulemaking, but you can't challenge adjudications under due process. Or, excuse me, the other way around. And they said that this applied equally to everybody, even if it affected 59-year-olds more than 40-year-olds. So Quesada's argument was, well, wait a minute. This law doesn't affect everybody equally because it affects 59-year-olds more than it affects 40-year-olds. The court rejected that and said, nope, everybody who turns 59 or who turns 60 will be affected this way. So they argued that this was rulemaking, not adjudication, and as a result, there was no ability for him to challenge that. What about the number of parties affected? Well, the more parties that are affected, the more people that are likely to want to challenge that decision, and that becomes a real problem because if you have millions or thousands of people challenging agency regulations and you have to have an adjudication for every single one of them, well then that's going to get really bogged down, and it's simply impractical to give large numbers of people a chance to be heard in an adjudicative setting. Equally important, think about this. Let's say that you individually get hit with a special property tax assessment, a real big increase, and you want to complain about it. You want to go to your local government to have that changed. Well, what happens if you try to go to your neighbors and you say, hey, I've just been ripped off. Will you help me get justice? Will you sign petitions for me? Will you go to board meetings for me? Will you go to write letters to the editor? Will you help me get this policy changed? And most people, the vast majority of people, are going to say, no, I'm not going to do that. I'm sorry that your taxes were raised, but it ain't my problem. I'm not going to spend that time. So, policies that affect only a small number of people, those small number of people usually do not have any political recourse in order to get that policy changed. However, if you have, for example, an across-the-board policy where you raise taxes by 40% on everybody, well, then that's going to piss off a lot of people. And a lot of people are going to get involved. A lot of people are going to come down to their city council meeting, and they're going to attend other meetings, and they're going to write letters, and they're going to be politically engaged. And so decisions that affect large numbers of people, there's already a mechanism to change those policies and to get justice. But if they only affect a small number of people, well, then adjudication is probably the only way for that person to get heard. However, I want to make clear that the number of parties affected, although it certainly is important in determining whether adjudication or rulemaking is appropriate, this factor is simply not determinative. So let me talk about one case called Anaconda Co v. Ruckelshaus. In this particular case, the EPA issued a regulation limiting sulfur emissions in a particular county in Montana. It said no factory or mine could emit more than a certain amount of sulfur in a particular Montana county. The only thing was, at that time, Anaconda Company owned the only significant source of sulfur emissions in the county. So this was a rule, a general rule that limited sulfur emissions, but it did affect only one company. And the company said, hey, you got to give us a hearing. You got to give us a hearing because we have been damaged and we're the only ones being damaged. So, it's a small number. They demanded that they be heard. The 10th Circuit ultimately rejected their argument, saying that, yeah, you're right, you are the only company that's being affected, but the rule is still a general rule, and of course it could still apply to other companies that decided to open up here in the future. So although the number of parties affected is significant, it's not determinative. Okay. So, if you're going to make a challenge for procedural due process, there are three questions that need to be asked. First, we have to ask the question, is state or governmental action involved? This is very important because, like almost all of the Constitution, it only applies to government and it only limits the actions of government. So the first question we have to ask is state or governmental action involved? Usually that's a pretty easy question to answer. The second question we have to ask is, does it deprive of someone of life, liberty, or property? Remember, that's what we said. The Fifth Amendment protects you. It protects your life, it protects your liberty, it protects your property. So we have to ask, has somebody been deprived of one of those three things? If they haven't been deprived of one of those three things, then they don't have a case. And then finally, if the answer to both of those questions is yes, the government's involved somehow, they've deprived someone of their life, their liberty, or their property, well, what do we do about it now? What processes do? So let's take a look once again at each of those three factors. First, let's take a look at life, liberty, or property. It says that the government cannot take your life, liberty, or property. Now, the nice thing is, if you're a public administration student, very few of the actions that you're ever going to be involved with, or very few of the actions that government itself is involved with, involve the deprivation of life. Deprivation of life, we're talking here, of course, about the capital punishment. So we're really talking about the judicial system, prisons, things like that. So you're usually not going to have to worry about that. Same thing with deprivations of liberty. Most instances, most lawsuits or legal actions that you might be involved in one way or another as a public manager are not going to be criminal lawsuits. They're going to be civil lawsuits. So usually people are not going to have to worry about going to prison. So for the purposes of this class, we're not really much concerned about deprivations of life and liberty. What we are generally concerned about are deprivations of property. Because most administrative actions that are challenged under the Due Process Clause are challenged as involving deprivations of property. So, it's important to understand what exactly the courts mean when they use the term property. Now, before we get into this, we once again need to step back, go back in time. And once upon a time, the courts based their due process decisions in this area on something that is known as the right-privilege distinction. What this means is that early American courts applied procedural due process very, very narrowly. They said that the Due Process Clause only applied to deprivation of your rights. And they defined rights very narrowly, just as they define due process. And in fact, many of the things people got from government were not considered by the courts to be a right. They were considered to be a benefit. So if you worked for the government, you had a governmental job, that wasn't considered a right, that was considered a benefit. If you got an unemployment check, a welfare check, food stamps, these were not considered a right, they were considered a privilege. And as a result, they could be revoked from you very, very easily. Let's talk about an example case, McAuliffe v. Mayor of New Bedford, decided by the Supreme Court in 1892. There was a police officer. He was engaging in political activity off the job. He was not doing this as an employee, but he was critical of the mayor. The mayor fired him. He claimed, well, I've got First Amendment protection. I'm a American citizen. I have the right to be critical of the mayor. But in a 9-0 decision, the United States Supreme Court disagreed. And they used the right-privilege distinction when they said, he may have a constitutional right to talk politics, but he has no constitutional right to be a policeman. The servant cannot complain as he takes the employment on the terms which are offered to him. So, basically said, sorry, you may have a right, but we're not going to protect you in that right, again, unless it's going to jail. Virtually any other thing, any other punishment government might impose on you is all right, because we're simply going to call that a privilege rather than a right. So this obviously reduced the protections of the Due Process Clause. Now, over time, of course, concern grew about this right-privilege distinction, because, of course, it leaves very important decisions to the arbitrary whim of supervisors. The decision of whether somebody has a job or not, if there's very few decisions that are more important. If you can't house your family and put food on the table, then that's going to create a chilling effect for free speech or other rights for governmental employees. And of course, this problem became bigger as government expanded. Back in the 1890s, government wasn't that big, but after the New Deal and lots of entitlement programs, welfare programs started to come about, the problem became bigger because this then gave governmental agents the right to just cut people off from benefits with virtually no discussion. An important case in this area is the case of Goldberg v. Kelly, and that is excerpted in your textbook, and we will talk about that in class, so please do make sure to read that. So, we talked earlier about the fact that in the Londoner case, the property tax opponents demanded not just a written appeal, which they were granted, but they asked for an oral hearing as well. And so that's going to become really important, because that's going to be the case in a lot of the cases that we're going to talk about going forward. Oftentimes, people will be granted a written opportunity to explain themselves, but what they really want is an oral hearing. And so the question to ask is, what's so important about an oral hearing? And I would ask you to ask yourself, if you were going to have your welfare benefits cut off, or if you were going to be expelled from San Jose State for something, would you want an oral hearing? And if so, why? Why is an oral hearing so much better than just something in writing? Well, again, your book talks about Goldberg v. Kelly, but the upshot is that some kind of procedural due process is required when there's the loss of an entitlement. So in Goldberg v. Kelly, this was a major case, and in fact, they still refer to Kelly hearings that are required by this particular decision. The Goldberg v. Kelly decision shattered the right-privilege distinction. If you are entitled to something under the law, maybe that's a privilege. The law certainly could be changed and that could be taken away from you. But if you're entitled to something under the law, well then all of a sudden some sort of due process was required. Now we haven't said how much due process or what kind of due process is required, but but at least some procedural due process is required, whereas before it was not. Now, it's important to note that this doesn't have to be a full trial. When we're talking about adjudication and procedural due process in this class, it is not required to be a full trial. And ultimately, the court says, how much due process does a person do? Well, they are entitled to the amount of due process that depends on the level of hardship that the policy is causing them. So if the hardship is minor, if it's just a minor burden on somebody, well, then not much due process is required. But if it's significant hardship, so for example, if somebody's going to be put to death, or if somebody's going to be fired from their job, or if somebody's going to lose their benefits, those would cause significant levels of hardship, and a higher level of due process would be required. In this case, the hardship was severe in Goldberg v. Kelly because, of course, we were talking about cutting off somebody's unemployment benefits. The court said, the extent to which procedural due process must be afforded the recipient is influenced by the extent to which he may be condemned to suffer grievous loss and depends on whether the recipient's interest in avoiding that loss outweighs the government's interest in summary adjudication. So this is just a complicated lawyer's way of saying that the more the damage, the more the government has to hear you, the more due process you are entitled to. A pre-termination evidentiary hearing is necessary to provide the welfare recipient with procedural due process. Such hearing need not take the form of a judicial or quasi-judicial trial, but the recipient must be provided with timely and adequate notice dealing with the reasons for termination and an effective opportunity to defend by confronting adverse witnesses and by presenting his own arguments and evidence orally before the decision maker. And this seems fair to me. I hope it does to you as well. When you are about to have your welfare benefits cut off, or if you're going to be fired for something that you think is unfair, you want to have an opportunity to appear before somebody in an oral hearing, to appear as a human being. You're not just merely words on a page. You are a human being, and it gives you an opportunity to force the decision maker to really focus in on the parts of your argument that you think are strongest. And I think everybody would prefer to have an oral hearing rather than merely a written one. So Kelly v. Goldberg established the fact that if somebody's entitlement is being damaged, then they have some form of procedural due process coming to them. But Goldberg left two more questions unanswered. First of all, this case only dealt with statutory entitlements. In other words, these individuals were entitled to these welfare benefits under the law. Are there other property interests that come in addition to statutory entitlements, or are statutory entitlements the only property interest that's out there? And then, of course, the big question, how much due process is required? You've got to have more, the more damage there is, but how much due process is actually required? Let's consider that first question. What is a property interest? Let's take a look at an interesting case, and I'd have you think about this, whether you would call this a property interest or not. Washington Clinic for the Homeless v. Berry. This was decided by the D.C. Circuit Court of Appeals. The city of the District of Columbia created a bunch of temporary shelters for eligible homeless families. So if you were a family and you made less than a certain amount of money, you were eligible to stay at one of these temporary homeless shelters. The only problem was money was limited, of course, and the District of Columbia did not have enough space to build shelters for all of the families that were eligible for this program. Of course, this clinic for the homeless sued, and ultimately the court ruled that there was no due process that was due to those families who were turned down for a homeless shelter because, they said, the ordinance did not create an entitlement. If it had created an entitlement, then homeless families who were denied room at a shelter would have an opportunity to make an appeal. But because the court ruled that this did not create an entitlement, then there was no due process available for those who were denied shelter. So no notice, no hearing was required when an individual or family was denied shelter. So your book talks about the case of Perry v. Sindermann. Perry v. Sindermann is a case having to do with a community college professor who claimed a property interest. And in class, of course, we will talk about that case. Your textbook contains two other cases on this topic of what is property and what's not. One is Garcetti v. Ceballos. The other is Goss v. Lopez, and we'll discuss both of those in class. So, assuming that the court has answered yes to that second question, that there has been a deprivation of property, then, of course, we have to figure out what process is due. And the process that, of course, is due is only due when a litigant can demonstrate a legitimate claim of entitlement, as we've just talked about. And so if they can't do that, the case is over. So that's our first question. Do they have a legitimate claim of entitlement? If they don't, the case is over. If they do have a legitimate case of entitlement, the court then has to decide what process is due. As we're going to talk about over the next few weeks, there are some core elements of due process. One is the requirement of notice. The party that is going to be adversely affected must be notified that they are being adversely affected, and just being informed of what's going on is fundamental. They also have the ability to receive some form of a hearing. Now, what form that hearing will take remains to be decided, but they must have a chance to be heard. So they need to be notified, and they must have a chance to be heard. But what form must these take? There are lots of different ways of notification, forms of notification. There are lots of different forms of hearing. Well, you have three cases in your book that try to shed light on this, so we won't be talking about it much in this video. Mathews v. Eldridge, Gilbert v. Homar, which some of you have briefed, and Ingraham v. Wright, which involves school paddling. So we'll talk about those in class. As we already mentioned, one of the most important determinations is whether or not there will be an oral hearing. And as we've already suggested when we talked about the difference between rulemaking and adjudication, if the decision turns on the facts of an individual case, an oral hearing is usually required. These are what we called adjudicatory facts earlier in this lecture. But if the decision turns merely on scientific evidence, then an oral hearing is usually not required. So, scientific facts are generally not litigated in court. Well, that's it for this lecture. The next lecture deals with agencies and due process from a different perspective, and that is the perspective of information gathering.